Hi, my name's Ryan Stodtmeister. I'm an estate planning attorney with the law firm of Anderson, Dorn and Rader, and I want to talk to you real briefly about 3 common mistakes people make when they do their estate planning. The first mistake is actually that they don't do any estate planning. And when you don't prepare any estate planning documents, you die intestate. To die intestate means to die without a will. And when you die without a will, the state of Nevada has provided a plan for you, and it's going to leave all of your assets to your closest living relatives. Whether you like those relatives or not, it's going to go to your closest living heir. That's the first mistake. The second mistake people often make comes from some folk internet wisdom passed down through the ages that says, well, in order to avoid probate, just put your children on your assets as joint tenants. Put them as co-owners on the house. This is a terrible mistake, and it's not even really estate planning. Holding assets in joint tenancy is merely a way of owning assets, of holding title to them. And let's say you do put your children on the title of the house. 2 bad things can happen. First, you lose control over the disposition of that asset. Let's say you put your son or daughter on the deed to the house, and then you want to sell some years later. But your child always had the idea that they were going to inherit the house and live in it. They don't have to sell with you. They don't have to sign off on that. You've lost total control. The other problem comes is that you now share liability with other people on your house title. That means if your son or daughter gets into a car accident and gets sued, or they stop paying their bills and there's creditors coming after them, those creditors and judgment creditors could come after your assets that the children are on, regardless of the fact that they live in the house or not. The third mistake people often make when doing estate planning is thinking that all I need is a simple will that says when I die, it goes to my spouse, and when my spouse dies, it goes down to our children. The problem with that thinking is that a will puts you right into probate court, which costs a lot of time and a lot of money. The other thing is that just a will does not suffice. Your estate plan should include many other documents that help you avoid guardianship, provide for healthcare agents to make decisions later on, and other important documents. So, to avoid these 3 mistakes, we recommend a living revocable trust. A living revocable trust is a document designed to avoid probate, avoid any unnecessary guardianship proceeding, and allow for many benefits if you ever become incapacitated or if you pass away. If you'd like to learn more or discuss forming a revocable living trust, we invite you to a free consultation with myself or other attorneys. Thanks for watching.